Well, welcome to question 67 of the Secunda Secundae. The topic for this lesson is injustice of a judge when judging. Um, and I'm Dr. Thibault. This topic I don't suspect is going to get a lot of hits just because it's one of these that's kind of interesting in a very narrow sense, but not particularly as interesting as things like murder or theft or robbery or one of these really hot button topics. This is just almost common sense in some ways under our current modern system of law. So, in some ways, you might feel like this is a bit redundant or overly simplistic. Well, it might not have been as overly simplistic in the Middle Ages. We take for granted that some of this has been implemented into the current legal system. So, when he's talking about judging, this into context of where we're at. We're looking at the issue of justice. We're looking at commutative justice, which is the justice between individuals in a society. And within that, we are looking at vices of commutative justice. And previously, we were looking at through 64 through 66 deeds of injustice. So things like murder or striking somebody or imprisoning somebody or maiming somebody or robbing or thieving from someone. So these were deeds, these were unjust deeds. But this one is injurious in terms of words. So how are these words injurious? And this is specifically looked at through the form of a judge. Now, often today when we would look at distributive versus commutative systems of justice, probably off the bat, I would think of a judge more um, as a distributive theory of justice because in some ways they represent the public. But this is under the topic of commutative justice between individuals. So it's looking at the judge as an individual within a society. So how does as this individual of a judge, how do they interact with society? I think that still, even with that framing, there's still some element of distributive justice kind of mixed in. Um, Question is really who can judge and what is the capacity of being able to be a judge. Um, so a judge can only justly judge those who are under his jurisdiction on matters either ordinary or delegated. Um, as you probably have heard by now, I don't know if this is your first video that you're watching, but very non-inclusive language. But in order not to be repetitive, I just keep the masculine that St. Thomas wrote with. Um, St. Thomas, all judges are men, which probably at the time all judges were men. So substitute in her if it makes it easier. Um, so the judge only has jurisdiction over those who has been given jurisdiction by the public and by the prince or by whatever legitimate authority, and they only have the ability to judge what they have been allowed to judge, which is either by ordinary powers, so a judge of a traditional civil court might have uh, jurisdiction over criminal cases, and you might have a judge who's over probate cases. You might have another judge that deals with real estate, or another judge that deals with copyright laws. Same idea here. You have jurisdiction over what you have jurisdiction over. For some, it is all things ordinary, like a Supreme Court of some kind. Some things are delegated, like a probate court. Um, so you can only have jurisdiction over this, what you have been designated to have jurisdiction over. Says Christ in his own accord submitted to the human judgment, and thus too did Pope Leo submit to the judgment of the emperor. So this idea that really doesn't matter who you are, you can still be subject to human judgment and human jurisdiction. sense, Christ is now under human jurisdiction because of who he is. At the same time, he leads by example of submitting himself to earthly jurisdiction on human matters. Likewise, the Pope did as well. So, if Christ and the Pope can submit themselves to the will of public authorities, then I suppose the rest of us can as well. I've tried to figure out what St. Thomas was talking about in this incident of Pope Leo submitting to the judgment of the emperor. He's very clearly writing about St. Leo the Great, St. Leo the Pope Leo the First. What I think he's referring to is when the emperor asked Pope Leo to go out and negotiate a peace deal between the barbarians and Rome. And there was a good working relationship between him and the emperor. So it's not entirely sure that Pope Leo was, he wasn't, I don't think, brought ever before a court of law, but perhaps the secular authorities asked certain things of him in terms of earthly responsibilities, and he submitted himself to that wish, although I think it also served the church as well, bringing peace. Can a judge use private information in a judgment? Now, this part, it could be confusing if you're reading this. I'm assuming some people who are watching this video might be a student of the Summa, maybe at the undergraduate level or perhaps graduate level. On the fast reading, it sounds like if the judge knows certain information, firsthand information, then can the judge use that firsthand information in the court case, or can they only judge based on the evidence presented in court? And St. Thomas says, no, you can't use your private opinion. Although I think when you look at the fullness of everything he wrote in that article too, he seems to be pointing to the idea that this private information is more like a person coming and giving, whispering in your ear, as this kind of henchman is in the picture, right? Somebody who's whispering to you the secret information that is not public. Because you can always use public knowledge, public information, and you can use that private information that you've been received. If somebody's tipped you off on some insider information that could be really important to the case, you could always, in some ways, as the judge, direct evidence, direct the court in order to explore those private allegations that you heard without ever saying it publicly. You could try to, through the prosecution defense, try to ascertain the actual truth and get it put into public record, the real truth behind that gossip that you might have heard. But if nothing can become public, nothing ever comes about from that questioning, then you can't use it. And St. Thomas, he points to this idea that the judge belongs to God in virtue of his powers. Judgment should be based on truth and not on gossip or opinion. It shouldn't be based on this private knowledge that somebody's whispering in your ears. If it can't be public, it can't be out there as truth, and everybody can agree upon it, then you can't just use the gossip somebody told you. Seems fairly obvious under modern standards, both the first and the second article. Fairly obvious. You only have jurisdiction over who you have jurisdiction over, and you have to use the knowledge presented in the court to ascertain the truth. And you can only base your decision on the truth and not on hearsay. So that seems quite obvious and is consistent with modern standards. Can the judge sentence the unaccused? Kind of an odd question to ask, but it comes down to this idea that the judge can't just walk around town judging people. There is a process to this whole thing, I think, is an important element of it. A judge is not like if there's an off-duty policeman, well, if they see a crime, they should step in even though they're off-duty. There's no off-duty judge who brings into action anytime they see some type of injustice in the world and start delving out judgments. The judge has a judge when they are sitting on the bench and they have been, and there is an accuser, prosecution, which has accused somebody and somebody that has a defense. This process is an essential element of being a judge. You're not a judge without a prosecutor and a defense. Uh, um, so this I so this idea that you do need an accuser of some kind. He does give a big however though. The however is there is no need for an accuser when the crime committed is notorious. Notorious RBG behind me. Um, if the crime is notorious as Cain has slayed Abel, the earth blood has cried out for justice. Right? This idea that when there's a genocide, when there's something of tremendous, notorious, which means famously uh, unjust and illegal action, that uh, the accuser is everybody at this point. Everybody is able to see it, right? You don't have to have a specific individual. I guess it's more like a class action suit. um, or in terms of in American criminal law, or common law, criminal law, this idea that the state is the accuser in some sense. Somebody has murdered somebody. Well, the person who's been murdered isn't a very good witness at that point. They're not a very good accuser if they've been murdered, but the state can still prosecute the crime as the accuser of them. It's responsible for making that case public. Can a judge lawfully remit punishment? Oh, and I apologize, on this slide it says Article 1 when it's Article 4, but ignore that. Can a judge remit punishment? I think this is probably the most interesting question within these four articles. And it says the sovereign who has full authority of the Commonwealth can lawfully remit punishment to a guilty person provided uh, the injured party consent to the remission, and this does not seem detrimental to the public good. Now, this is not consistent with the modern American legal system or the, the common law system. The idea that a judge cannot remit uh, judgment unless the injured party consents to it. Well, that actually isn't part of the system. If the injured party does write a letter to say, please be lenient, the judge might take that into consideration, but the judge is not subject to the consent of the injured party. In some ways, it's almost an oxymoron in the statement where it says the sovereign has full authority, because if they only have full authority, if the injured party consents, that doesn't actually sound like full authority. Sounds like uh, partial authority. But I think if you focus on just this part, this technical part, too much, it misses the kind of theme throughout this Article 4, which the theme is that the judge does not have that much authority to remit punishment. Says in matters that are determined in accordance with divine and human laws, it is not left to him to show mercy. Uh, this idea that Christ was merciful. God might be merciful in the final judgment, but it is not up for a Christian judge to say, we've let everyone free. We must forgive, right? We must be Christians, so we must forgive. So then you just let everyone free, because it is a violation of the common good. If you release rapists and murderers with no punishment, and if every rapist or murderer and thief before you knows that you're just going to let them go, then then there is no law at all. There's no teeth to the law if the judge isn't willing to enforce the law. So if the law is good, if the law is to provide freedom and protection and security and aim at virtue, right? The purpose of the law is to guide man towards virtue. If that's the purpose of the law, and you were to give the law no teeth, you were to uh, emasculate the law, then it has no ability to direct man towards virtue. It only um, encourages unethical people to continue to be unethical in this life, which ends up creating the damnation of their soul in the next, for one, and it injures the lives of people in life here and now. So in both ways, it's not good to be too merciful. It says that the judge uh, can be merciful in areas where the judge has levels of discrepancy. If that's put into law, the judge has some discrepancy, perhaps the length of the sentence, the judge might have some discrepancy there. It's fine for the judge to be merciful in that case, assuming that keeping the public good in mind. But he doesn't really have the ability to do a full uh, remission of punishment, except for this example here where uh, the injured party consents and the public good is not hurt in that. Kind of an interesting take. I think this last one is probably the most different from the American legal system. In conclusion, it's a fairly short section. The judge can only judge where he has jurisdiction over the subject matter and over people who has been given jurisdiction by valid authority of the public. Um, the judge must decide based on facts, not opinions, not on gossip, hearsay. Judge requires more than one party to be involved in a typical fashion. There needs to be an accuser, there needs to be a prosecutor, there needs to be a system here of opposition in order for the judge to look at both sides and come to a judgment. Um, and a judge can show discretion, but only within certain limits, because again, if the purpose of the law is to direct man towards virtue, and then you were to just throw the law out, give it no authority, because you just say, "Well, forgive and be merciful," well, then it doesn't have it doesn't then direct man towards virtue, and in fact, it might put the man's soul in danger and put the lives of the commonwealth in danger as well. So, very brief section. So I will see you next time.